I don't. I agree that I think all people exaggerate. I think it's almost like the way we over communicate with each other, lawyers, disabled, doctors, everyone, friends, family. My mother, God, my mother loves to say to me, "You never call." I'm like, Mom, we call twice a week and FaceTime with your grandkids twice a week. I know it's never. I'm like,
Yeah.
I'm like, okay, So, for her, it's just that emotional, it's driven by emotion. Like, it's not enough,
Yeah.
I feel like so many claimants, it's emotional roller coaster dealing with their disabilities. And it's not an intentional, I'm trying to exaggerate. I'm just trying to emphasize to you how it feels.
I think that's a really good point, Peter. And, most of these people have been waiting 2.5 years, with no income, no job, I mean, it's like they get into court and they just want to let it all out, They've been holding it in for so long. And, they may exaggerate, but that doesn't mean they're not disabled.
Your Honor, welcome back. This is going to be part 2 of our sort of, little things that happen in a hearing room. Last week, we talked about the CDI investigation, or I should say in part 1, we talked about the CDI investigation. Does Social Security spy on you? Well, the answer is yes, sort of. And then, so go watch.
Only if you deserve it. Yeah.
Yeah. Only if you trigger some red flags.
Yeah.
And really interesting because I've actually learned a lot. Just the fact that you didn't hold him that credible is something new to me. I didn't realize that. I thought, maybe you found him more credible than not, but you really didn't all these years.
No.
And then today I wanted to talk to you about, because we get questions from clients outside of just their regular testimony, which you and I, I shoot a whole nother podcast on just how to testify.
Mm-hmm.
We did a mock hearing video, which I'll add the link in, where you played the role of the judge and I played the role of the witness. And we talked about kind of how to testify in court. But one of the things we get questioned about, are sort of the auxiliary things around the testimony. And I wanted to pick your brain about, especially from the perspective of a former judge. And what I mean auxiliary is like, especially in-person hearings, and we can talk about phone and video here kind of as well, but really in person. From the minute the claimant walks through the door into a hearing room and before they open their mouth, what are things that, that you'd be comfortable sharing, first and foremost, that you're making observations about, about that claimant, and so forth. So, so for example, I always get asked, what should I wear to the hearing? And I've seen different lawyers answer this question so differently. So before we give our opinion on it, I'm just saying this is our professional opinion based off of your,
sure,
years of being a former Social Security judge and, or 20 years of private practice. I don't know these numbers are exact, but and serving our country, which, by the way, thank you. And just being an amazing lawyer and an amazing judge, what are some of the observations you make around sort of those peripheral things going on in the hearing?
Well, let me say first, so the judges, I believe, universally read the record very thoroughly before you ever come into a hearing. So the judge is going to know what you're claiming and what the basis for it is and what the evidence in the file is. And I would say that a judge would normally have a general idea of what direction they're going to go in the hearing. And we've discussed this before, but most of these hearings really for a judge are going to come down to 1 or 2 questions that need to be answered. That might be credibility. It might have to do with their past work. They might be fully disabled, but they've got earnings in their record, or whatever the reason was that they were initially denied, that is probably going to be one of the big issues in a hearing. This does remind me, I want to remind you that you and I are going to do a podcast soon about representing, how important it is to have a particular, a good representative, because that, for me, when I was a judge, there were some particularly offensive representatives that would appear. And if you are a claimant and you got an attorney or a representative who is offensive, antagonistic, flat-footed, doesn't answer the judge's questions, you always have the right to ask for a different representative, because the lawyer or the representative works for you, okay? And if they're not doing their job for you, then you're entitled to get somebody else, all right?
Yeah.
A digression, but there's a lot more to be said about that.
One of the podcasts that I want to kind of shoot with you when, here in the next coming weeks is, what is it, maybe the top 10 things to look for in a good lawyer? What are the top 10 things to avoid in a bad lawyer?
Yeah.
And let me ask you this, because you're basically saying before the client walks in, you're seeing who they're represented by.
Yes.
On a scale, and as a former judge, and if you're comfortable answering this, on a scale of 0 to 10, how much did that matter to you? 10 being it mattered a lot, 0 meaning none. Of course, you would never hold it against the client if the medical records base that. But
no. But I would say I would put it at about a 7 or an 8. It's to me as a judge, it mattered a lot. Now, part of that might be my orientation, and which is that the truth comes out when both sides are well represented. In these inquisitorial hearings for Social Security, there's only one side. So the judge kind of has to play the other side. So you got a claimant's rep, and then you got the judge who wears 3 hats. So as you know, Peter, a judge, these are administrative proceedings. There is not a representative for the government or for Social Security. Person is making a claim for their benefits. So one of the hats that a judge has to wear is to be the foil to the attorney representing the claimant. And by foil, I don't mean in an antagonistic way, but rather in an inquisitive way. A lot of representatives will they'll be very one way. They believe that their job as an advocate is to be like this knight in shining armor for their claimant, but they kind of forget that we're all looking for the same answer in these cases, which is the truth. Is this person disabled? Does this person fit within the parameters of the Social Security disability law or not? And the second hat that a judge has to wear is as a de facto trustee of the Social Security Trust Fund, because I've already noted in earlier podcasts, the average value of one of these claims is probably about $300,000. And that's money that is in the Social Security Trust Fund that we've all contributed to. So the judge has to wear that hat, and then he's also got to be the arbiter of the proceedings. So,
right.
I would say
poorly represented.
Yeah. Then the judge has.
If they're poorly represented, then you wear this other hat.
Yeah, exactly. And it makes it much more difficult. It makes what could be a very easy, smooth proceeding into a very difficult proceeding for a judge. And frankly, you clerked for me for some years when I was a judge. And as you know, there are some things that would irritate me, and it was kind of hard to push my buttons. But one of the things that would irritate me is a representative who did not uh, adequately represent their claimant. And so the judge has to do that under those circumstances.
Right. It becomes this weird. Sorry, there's a little echo. It becomes this weird place where it's all of a sudden you're sort of having to look out and not represent is not the right word, but look out for the client's interests as well.
Yeah.
When their own attorney can't do it. And I think one of the, and I don't disgrudge a lot of lawyers if they're going to be in there advocating profusely and citing to records and just, 100% I'm all in on my client.
Yeah.
I don't begrudge those guys. What I begrudge, and this is based off of my time working with Social Security with, the different judges. Mm-hmm. And what I begrudge is a lawyer who did not read the file.
Right.
Not even advocate.
Right.
Because you are just there for the ride.
Right. Exactly.
And you didn't take a beat. You didn't take a minute or the hour or 2 hours or 3 hours or whatever it may be.
Yeah.
Read your own client's medical record.
Yes.
Understand both the technicalities of Social Security.
Right.
With this particular case, like, hey, I've seen judges say, okay, counsel, give me an opening statement. They say, oh, Honor, I waive opening statement. I prefer to give a closing, because then they can just make the closing up off of what the testimony was.
Yeah.
But then if there's an issue with what's the DLI, and like, I don't know, or what are the severe impairments in this case?
Yeah.
Oh, let me, you can tell they haven't read the file.
Yeah.
And to me, that is horrendous representation.
It is. Yeah, it is. And the judge is responsible for the result. The judge is always going to be responsible for the result. So garbage in, garbage out, as long as you've got good facts in there to support whatever your conclusion, and they have to be on the record. They have to be in the written record. They have to either be in testimony or even argument if it's supported by written evidence. But there's got to be some degree of advocacy, even though these proceedings are inquisitorial, because, I read the record and I know what it looks like as the judge, but, I want to hear your story.
Let me ask you this, just because I'm running up a little bit against time here, but I wanted to ask you about, what about when literally you're paying attention? So you've read the file, and let's say it's a combination of physical and mental health impairments. Mm-hmm. File is adequate, and there's a few questions you have. How much do you care of like who opens the hearing door? And the reason I ask that is you have a former colleague who we both know, and I'm not going to name drop this person, but you have a former colleague who told me once after a hearing, oh, I watch if the claimants can open the door, because man, that door is like 30 pounds.
Yeah. Yeah.
And I'm like, are you joking? So I didn't know if he was joking. So from there on out, I always open the door for the claimants. I'm like, do not open that door. I'm opening the door for you. Right.
Yes.
How much did that, like the little things, like opening these big, heavy, thick doors to get into the hearing room matter to you?
I never really paid that much attention to that. If the person has exertional limitations that affect their ability to walk or stand, I'll watch how they walk and stand. If they've got a problem on their left leg and they're using the cane in the wrong hand, or they're using a cane and there's no prescription for it in the file, those are the things that I would pay attention to as a judge. But I would also probably ask them, I'd give them an opportunity to explain. And as an example, some people need a cane for balance. Some people need a cane to support their weight because they've got a back problem or a leg problem or whatever. But that doesn't mean that a cane doesn't help them if they don't have a prescription for it. If they've got a legitimate explanation, for instance, a person with vertigo, I would think they'd be using a cane, whether it's prescribed or not. You get dizzy and you don't want to fall down. So, if there's a legitimate reason, I'll ask the claimant. All judges aren't like that. A lot of judges will just, draw a conclusion. write it down in their notes, and then, you missed it. And that's why it's important for a lawyer, a representative, to bring this to the judge's attention. I've always been a big believer in the more evidence I have, the better foundation for my decision. And that's good evidence, bad evidence. I don't really care. I can choose what I'm going to rely on, but I've got to at least have something in the record about it.
How much did it matter to you as a judge the way the claimant dressed, whether they were in a T-shirt versus a polo shirt versus a dress shirt like I'm wearing today versus a whole suit, or for ladies, a dress suit versus, how much did any of that?
Well, we need to remember that these claimants need to remember that when they're going into court, this is a federal proceeding. It's a formal hearing. And so they need to pay respect to that. And that means being respectful to the judge and to the clerk. But it also means not just wearing sweatpants into court. I don't really care if somebody gets all dressed up. I want them to be comfortable when I'm a judge. Clean clothes. I don't care if it's just a T-shirt and pants. If that's all they have, let's say an SSI claimant or something, I don't really care as long as it's clean and they're not all disheveled and obviously have bad hygiene and that sort of thing. That, that's probably not a good way to present yourself.
Right. A couple other questions I have, specifically what kind of going on in the hearing, because the average hearing is about an hour.
Yeah.
Did you make observations, because one of the questions that especially come up in physical cases is the question of how long can you sit before you need to stand up? Mm-hmm. And usually that question comes in about 30 to 40 minutes into the hearing. I mean, I'm guessing,
Yeah.
And if the claimant said, man, I got to stand up every 5 minutes.
Yeah.
And they haven't stood. Yeah. And they haven't stood yet.
Yeah.
Did that
after an hour?
Yeah. Did that matter to you?
Yes.
I bring this up. It did matter.
Yeah.
The reason I bring this up, I don't know how, you had a mentor judge when you first started as a judge, and I worked for him too.
Yeah.
And he would call people out on the record.
Oh yeah.
Just testified that you can't sit for more than 30 minutes. It's been 45 minutes. Let the record reflect that the claimant is yet to stand. And I'd be like, holy cow, man, you're hardcore about calling this client out.
Yeah.
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 And it mattered to this judge in particular about the sitting question. And so it mattered to you as well. Did you ever call people out on it?
Never. No, some questions are just meant to antagonize. Right. You can make an observation. Also, we have a rule. It's called the sit and squirm rule. Have you heard of that, Peter?
Yes. But why don't you explain?
It's not really fair to judge a claimant based on how they're sitting or, it's not evidence really how they're sitting or whatever. There is kind of a collateral question though, and that is if a person says they can only lift 5 pounds and they came in with about a 40-pound purse, sometimes people exaggerate. And bear in mind, even disabled people exaggerate sometimes. So it's not the be all and end all, but I don't see any point in challenging somebody on something just to be antagonistic,
I agree that I think all people exaggerate. I think it's almost like the way we over communicate with each other. Mm-hmm. Lawyers, disabled, doctors, everyone, friends, family, my mother, God, my mother loves to say to me, you never call. I'm like, Mom, we call twice a week and FaceTime with your grandkids twice a week. I know it's never. I'm like,
yeah.
I'm like, okay, so, for her, it's just that emotional, it's driven by emotion. Like, it's not enough,
Yeah.
I feel like so many claimants, it's emotional roller coaster dealing with their disabilities. And it's not an intentional, I'm trying to exaggerate. I'm just trying to emphasize to you how it feels.
I think that's a really good point, Peter. And, most of these people have been waiting 2.5 years, with no income, no job, I mean, it's like they get into court and they just want to let it all out, They've been holding it in for so long. And, they may exaggerate, but that doesn't mean they're not disabled.
Right. The one thing I wanted to circle back to about the lifting, you talked about the 40-pound purse,
Mm-hmm.
And we're being a little facetious about that. But the same judge who we talked about earlier about the sitting question, he would make sure that his pitcher of water was filled.
Yeah.
He would say on the record, let it be known that the claimant just poured themselves a cup of water and I weighed that water and it is 10.7 pounds. And the client said earlier they couldn't lift more than 10 pounds.
Yeah.
I'm like, oh my gosh, Judge. And so I always tell claimants, let me pour you water. Let me hold the door.
Yeah.
Let me, do anything other than, and so I just think, and it's why I actually really encourage claimants to do phone hearings. It removes all of that, right? It's testimony and whatnot. I had a client once, and literally multiple shoulder surgeries, multiple. So on the record, when you look at it, it's like, shoulder surgery after shoulder surgery. But when she testified, you ever meet those people that are really animated when they testify? She's like, I'm going to tell the judge, I can't lift my arm above, literally physically doing this. I can't lift my right arm above my head. I'm not able to hold my left arm straight. And she's like doing what she's saying she can't do.
Yeah.
And I'm like, well, here's what we need to do. You need to sit on your hands because the judge is you're going to raise an eyebrow if you're like, I can't raise my right hand and you're actually literally raising your right hand.
Yeah.
And so, and it's hard because, I'm sure she's doing it with pain. And then now you got to explain all of it, as her lawyer.
Yeah.
And I'm sure the judge is like, well, wait a second. You said you never can. And the word never is defined. Oh man. And that your former mentor, he would open up the Black dictionary, or not Black's, but the Webster's dictionary and into these shouting arguments with the lawyers about, well, let's define the word never. Let's define the word moderate. Let's define the word, and, and I just kept my mouth shut because I was working for him. So, but to observe all this, it's like, it taught me well, like, be careful when you walk into that hearing room because you're going to have some judges that really use the minute you walk in to the minute you walk out and every interaction besides the testimony that can happen. Now, to your point, not every judge is like that, right?
Right. Not every judge is like that. And when we talk about representatives, we'll kind of hit that issue again. As far as what your representative or your lawyer's obligation is, to make sure that the truth is being expressed as much as possible. And also the importance of your representative knowing that judge, not personally, but knowing how that judge views evidence. That can make a huge difference, as you know, in the result. The relationship that attorney or representative has with the judges professionally, not personally, but professionally, and the reputation and, the knowledge that the lawyer has, what that judge is going to be looking at.
Yeah. I think that's why we follow statistics so close with every judge in the country. It's one of the things we can tell about a judge right away is just look at their, percent pay rate versus the next.
Yeah.
Let me ask you this before we wrap up. Are there any observations now, and I don't think and maybe this is true or not true, I don't know. Did you ever because I don't think they did MS Teams hearings until the pandemic. And
right.
So with video hearings and or phone hearings, what are some things, putting your judge hat on If you were a judge, would you be looking out, other than testimony? You mentioned like who's your lawyer, but what are other things that, because you're not going to see a cane on the phone. You're not going to see sitting, walking, lifting. They may be laying down the whole time. Are there things on the phone or in MS Teams, and maybe we should divide this up a little more clearly. Are there things on the phone with video chat, let's say, because I think that is probably the closest to an in-person hearing, other than things we just talked about, that you would take note of if you were a judge?
No. To answer your question, no. I think that, I think it's important to get a good foundation of the facts, no matter whether it's from observing what you see, listening to what you hear, knowing the record and knowing what the claimant is alleging, and so forth. Those are really the most important things. And if a person comes in or on video, whatever, let's say a person claims to have memory problems, Neurontin, gabapentin, those medications cause a lot of memory problems for sure. So if somebody claims that they're taking all this gabapentin and that they've got terrible memory problems, and then you start asking them questions about, what happened 10 years ago, or, why did you lose that job 15 years ago or whatever, and they've obviously got a pretty good memory, that's something you're going to consider. But I wouldn't necessarily put that in the same category as the observation of, how a claimant comes into court or anything.
Go
ahead.
Let me ask you this about MS Teams, which is basically like a Zoom type court.
Mm-hmm.
If you were a judge, would you care about what's in the background? Like, are they in a clean house? Is their house messy? Or, because a lot of times they're just doing a video.
Yeah.
I try to advise clients, just find a corner and have it pointed towards a corner so they don't see your house. But, just because you never know. With that kind of stuff, what do you think? You think judges care, don't care?
I'd be surprised if they even paid attention to that,
Gotcha.
Yeah.
On phone hearings, what about like background noise or what you see in hearings?
You do not want a barking dog in the background. You don't want, because, the phone hearings, you got to do them alone. You don't get to have somebody in your home or whatever next to you, your spouse, whatever. You have to be alone on a telephone hearing, and the judge will generally make sure that that's the case. But, there's no prohibition on having a dog in your hearing. But if that dog is going to be disturbing the judge or making noise or, whining or barking or something like that, it's going to irritate the judge, and there's no point in doing that.
Yeah. Well, the dog thing is funny because it depends on the judge. So during, now judges do phone hearings, and sometimes they do them from home. And there was a judge who I loved, an outlier on the other end of the pain.
Yeah.
Not the low pain, but the high pain. And this judge, and I'm not going to name drop, but would be like, "Oh, excuse me, I need to go feed my dog." And you'd hear these dogs just barking in the background. Take 2 minutes out of the hearing, still be on the record, go come back, and you could hear this judge is like, "It's okay," and I'm going to make up a name. "It's okay, Spot," and just you could hear the dog. You just in the background of the hearing, and just be like, "Okay, where were we? Oh, got a pet." You're just like, just a couple little things that I will say for in-person hearings.
Sure.
There's some judges that I know that are sensitive to smells, especially perfume and cologne. So I try to advise folks, don't wear heavy perfume or cologne in a hearing. There's some judges that they react strongly to that. I've been advised by some judges, like, tell your clients not to wear perfume or cologne in the hearing. It really can upset me. So just little things. And it is the benefit of the more you're in front of a judge, or in your case, you train some of the judges that are currently sitting. The more you're in front of a judge, the more you kind of know those kind of ins and outs about. But I will say it's why I personally and professionally, my professional opinion is phone hearings are the best, because it takes away almost 95% of what we're talking about today.
Yeah.
The way you dress, the way you move. You don't need to explain if you're sitting or standing. They're not asking you, are you sitting? Are you standing? Are you laying down? No one's asking that.
Yeah.
And so it removes the judge's hat. And I don't even think judges are really supposed to be wearing this hat personally, but it removes the judge's hat as a witness, because you're now witnessing and testifying. Not you, but, you know, we talked about other judges saying, oh, and for the record, the person, I mean, that's testimony, you know, and, you know, so listen, this is great stuff. I appreciate you so much. Your experience, it shines through. I think I still learn from you. Every time we talk, I feel like I'm learning something new, whether professionally or personally. And so I am grateful that you have chosen to work with us and at Evans Disability.
Thank you, Peter, very much. It's my honor to work for you, frankly.
That's way too sweet. We'll see you this Friday.
You bet.